Okay, y'all, we back. Let's get it. First of all, let me give a shout out to Law and Crime. Everybody should give Law and Crime a shout out for making it possible for us to lay young Thug a trial out. Okay, okay. Now on this section, on this part of Young Thug trial, you have Miss Love is trying to defend one of the cited that one of the attorney on the defense side were trying to say the girl in the attorney right here in the green, she got set up. She got set up because Woody said Wood. That's the one Woody fired. Now she is not supposed to be Woody attorney. It was told to her that that man would be back today, Monday, yesterday, y'all, in the Young Thug crime trial, but he didn't come back. So listen to this, and then I'll tell you, we'll talk.
What I believe that Ms. Bumpus wants to address with the court is strictly and solely the civil matter that involves the motion of the state to compel her client, Mr. Copeland, to testify, the offer from the state of immunity should Mr. Copeland testify, and the motion of the state to the court to sanction Mr. Copeland if he fails to comply with an order of the court pursuant to 24-5-507. That matter is a separate matter from the trial that is going on now. It is akin to the state moving the court for a material witness warrant for a person who refuses to obey a properly served subpoena.
He obeying. What you talking about?
Something to which either defendant is a party, and for that reason, it is our position that counsel for the defendants are simply wrong in this instance, and that
They love sit down.
Chooses to address the court with the state regarding a matter to which the state as a moving party and her client as the person for which the state made that motion are involved only, then the parties to that matter are the state and Mr. Copeland. And so for that reason, I believe that Ms. Bumpus is entitled to address the court with the other party in that matter, which is the civil contempt order entered by the court on the motion of the state at the time.
Now she really need to sit down. She the one subpoenas that boy to come to court. She the one put that immunity on that boy. Now you trying to sit up here and act like you trying to take up for his attorney. Don't do that, Miss Love. Don't do that. Y'all did this. Right now, he is cooperating. He just ain't cooperating like y'all want him to cooperate. Don't try to lock that boy up no more like that. Just because y'all want him locked up. He on the he taking a stand and he's speaking. He spoke for himself. She don't have to be his attorney. Y'all getting on my nerves.
The state moved the court to compel the testimony itself.
All right. I don't know what she's going to say, so that may
No, that right, Judge.
Ex parte or not. But what does he want to tell me, madam? Can you tell me the subject matter?
Yeah, about when he said he fired.
Well, no, that. We have to have a hearing on that issue. We have to have a hearing on that.
You the one took the job.
We'll have to have a hearing on that issue. That's not an ex parte matter. Okay.
Well, what I'm trying to say is something that happened during the ex parte matter, which is why I don't want to say it in open court.
No, I'm good. Go ahead and reduce it to writing, and your request to withdraw, and your client, which we'll bring back in, your client needs to be able to have a say-so on whether or not you can withdraw. And he should get another, and if he wants to have you and wants to get another lawyer. So.
Now go on and act like an
So
attorney.
that's it. No, I'm not gonna, it's
You're
not gonna.
supposed to be a lawyer.
Done?
As a result, Your Honor, if there's no ex parte communication, and I'm withdrawing my objection.
Okay,
I just want to make that clear to the court.
that's fine.
The court doesn't.
No, that's fine. You're doing your job. No, you're doing, no, Mr. Apple, I wouldn't say that. Okay.
I'm withdrawing the objection only with respect to this particular reason.
Okay.
I reserve it with respect to any other ex
All
parte
right, no problem. Okay, can we bring Mr. Copeland back in, please? Can we hold off until Mr. Copeland comes back in? Okay. Nice.
When you sitting up there talking to the state, why you keep going over there to her? She don't tell the judge what to do. And y'all the one gave him that, they the one gave him that immunity, little girl. That what you want. You want it. You thought them boys were gonna be easy. Oh, what he whispered to her and say? What did he say to his attorney? Should have took the job.
Last week's proceedings that Mr. Copeland was actually represented by Mr. Jonathan Melnick, and that the court required Mr. Melnick to be here on Monday, and Mr. Melnick indicated that
That's
he had
right.
non-refundable airline tickets and that he would have someone appear in his place. So I believe Mr. Melnick is still this gentleman's attorney.
We don't know that. We really don't know. I don't even know if he's entered an appearance for the purposes of this, the circumstances thereof, but I'm dealing with it from the standpoint of Mr. Copeland is on the stand, he's a witness, he's
That's
had
right.
counsel, he's gonna continue to have counsel. So that's the reason I'm stating it is at this point in time. Okay, sir? But
And
thank
she
you for
need to sit
putting it on
down.
the record, okay? All right, so Ms. Bumpus, follow your motion. But until such time, you're going to need to remain as long as Mr. Copeland is a witness. And once we've had an opportunity to hear that, then I'll go ahead and do that. But it's not timely to begin with because he's on the stand, he's testifying. Okay, so whatever arrangement you had with Mr. Melnick, I'm sorry that that's put you cross purposes with not being able to be released. I don't know what
She's scared.
difficulties it causes you otherwise, but I apologize on behalf of the court, on behalf of that, but,
And you're right, we did want to, the state wanted to put something on the record as well, that Mr. Copeland has satisfied at this point his contempt by testifying. So if he remains and testifies, then unless he wanted to, there would be no purpose for an attorney. So long as he remains and he testifies, that's the only if he pleads the fifth or fails to testify will he be subject to being placed in custody. So at this time he has purged his or satisfied his contempt because he is testifying. So long as he remains in this posture, then we believe the contempt will be completed and he would not need an attorney. So, but I can't.
well, but that's his choice. That's what the rule gives him 10 days to do. We're kind of saying, well, make that choice right now. We're telling him here in open court to do that. So
Right.
that's what the court's concern is at this point in time.
But Your Honor, I was representing him for the civil contempt, not as a witness. So that once he purged himself, I should have been released.
But that's you and your attorney. That's you got yourself in some. You got yourself in some. That attorney stuck you. Look at Woody, Mr. Chaos. He told you to go ahead on and fill out your paper, do your work. Fill out your paperwork. And you don't did what you supposed to did, then leave.
Yeah, have a seat. I'll call you back. Okay?
I'm sorry, Judge.
Then you can have a seat. I'll call you back.
And sit down. Go sit down. Go sit down because they the one did it, young lady. Why are you talking to them? You're not even supposed to be talking to the state. Look at her, y'all. He told her to go sit down. She's still over there talking. Go sit down. That's what you get. Y'all thought the trial was gonna be cute. Keep on going to the state. The state the one gave him the immunity. Why you keep going over there in their face? I just wonder. How y'all doing today? Those who just tuned in, we here with Mr. Chaos. That's Mr. Chaos, little Woody. Okay, his attorney, the guy who's supposed to be his attorney, has not showed up, y'all, in 2 days. It's the second day, and we're going on Wednesday tomorrow. And he supposed to be back out of town Monday. So he stuck that young lady who just finished talking. And she not supposed to be a witness for him. She just supposed to work for him for that Monday. And here she is. But he gonna let her go after she do what she need to do. Let's go. What we waiting on now? I think the judge need to step down, y'all. I'm just gonna be honest with y'all. Where his dog at? Look at Mr. Chaos, little Woody. Woody is an artist, y'all. He can rap. Woody playing crazy on them. Ain't nothing wrong with Woody. He just acting. I'm gonna skip it.
Well, but you still have the opportunity to.
Hold on. Woody said, you fired. I'm surprised he still let them call him Lil Woody. Because, honey, everybody in my family look like when they grow up, they don't want you to say Lil. Don't call them out my nickname. Call me out my real name. Kill me, these folks. I tell you, it's so difficult.
All right, Ms. Bumpus. At this, go ahead, Maddie. You can take the podium, please. At this point, the court is still of the opinion that you need to file a motion to withdraw and give your client an opportunity to respond to that. So, once you do that, and he has the opportunity to respond to it, I'll counter it, in fact, for unless he decides immediately that he wishes to not hold your required services, but usually he gets 10 days. So.
And how would the court know if he's deciding immediately? Because
Well, usually he's hearing. I mean, we have either the time passes and there's no objection that's filed, and you get it immediately when it's granted, or I set it for a hearing and he says, yes, I either don't want you as attorney or I want to have you as attorney. I'm going to get new counsel, or I've gotten new counsel.
And so Jonathan Melnick is just able to be released?
See, I don't know what the arrangement was between you and Mr. Melnick. I have no idea. That's not my purview.
Yeah.
All I know is that Mr. Melnick was here on Friday.
Why you
He
mad
said
at
he
the
was going
judge?
on a vacation. I don't know if he even properly entered an appearance in this case. I know that his leave wasn't appropriate in this case because he asserted himself as and represented to all concerned that he was in fact Mr. Copeland's attorney.
That's right.
So, and then Mr. Melnick said that he would have counsel for Mr. Copeland on Monday, and that was you.
Yeah.
You appeared on Monday. So I do think that you do need to properly
Call him.
withdraw and give your client an opportunity to do to have the full range of options. So until that's done, now Mr. Melnick may come back and may decide, well, yeah, I'm going to pick up, and I still represent Mr. Copeland, but I need to. I'll take up that issue when it was presented before me. Okay. All right. I'm going to set that, madam, for the morning of the 25th of June at 9 a.m. All right. Let's summon those please.
Y'all hear his dog?
Not speak. Hold on, Sergeant Ingram. Did you want your what your lawyer's not in here?
She's not my lawyer.
Well, but you still have the opportunity to decide that, okay? All right. Your client wanted to say something, and he said, you're not my lawyer, but as I told him, I was about to tell him that he has the right to decide that issue, and he has to be given due process to decide that issue. So that's why I want that done in this case, okay? Okay, all right. So, at this point, anything else? As in respect to Ms. Bumpus?
You didn't give me time to say that.
Okay, I'm sorry. What else did you want to say?
Mr. Melnick told me that she was only going to be here for 1 day. And that she was going to make sure that after she done then, it was going to be...
See, but I have no knowledge of those.
Y'all the only one know.
And because they asserted themselves as your lawyer, you have certain constitutional protections as being represented by an attorney.
Y'all being too secretive.
I don't know what was said to you. I don't want to know what was said to you.
I know that, right?
I'm just looking at who showed up and what they told us, meaning me and the other parties here. So I don't know, and that's my
That right, Judge.
that's my kind of pause in this particular circumstance is that I need to find that out. So filing a withdrawal would help the court in this particular circumstance. Yes, Mr. Allen.
My application is always called education and work. Uniform security protocol does indicate 10-day requirement to pay client consents to the law.
I tell you what, Mr. Copeland, I'm going to send our jury to lunch. I'm going to let you talk with Ms. Bumpus afterwards, okay?
All right.
And then.
All right, y'all. It's just a few minutes ago they had took their little break, right? So what the attorney did over the little break turn, while everybody taking their little break, she ended up typing up her letter and gave it to. She gave her letter recommendation to Your Honor, and he gonna dismiss her. Okay, so they be more like. Woody is defending his own self without an attorney. That's what's going on now. So we back in court now with Judge Glenville. She wasn't playing. She got that note.
All right. Sergeant Ingram, are all our participants here?
Yes, sir. That's great.
Okay, all right. Counsels, I have a letter from one of our jurors, to mark as the next course exhibit in order. And, because, it references, I'm not disclose what type of procedure a juror's gonna have, but this document, did you sign that document?
Yes.
All right. Did you have an opportunity to talk with Ms. Bumpus, your satisfaction about pros and cons of her withdrawing as your counsel in this case?
Yes.
Do you wish for her to go ahead and withdraw as counsel?
Yeah.
Okay. All right. All right. Let me have that back. One moment.
Yeah, lady,
Okay,
you.
I'll mark this as the next court exhibit in order, madam. We got it. We'll just mark it as the next court exhibit in order. Do you need a copy of it to file with your? Because it'll be made part of the record. But do you need a copy of it?
No, Judge.
Okay. All right. All right. So I will go ahead and authorize you to withdraw as his counsel in this matter. Okay.
Thank you, Judge.
Okay.
I'm excused.
Not quite yet. Madam, as a result, I'm going to also have you appear on the 25th of June. I have filed an order to show cause, and I'm going to give you a copy of it. You can read it, acknowledge it, just that you received a copy of it, and we'll see you on the 25th of June at 9:30 in courtroom 1C.
All right.
So you need to be here for that day, okay?
Okay.
All right. We'll see you then.
Look at Woody, y'all. Mr. Chaos. Now you got to represent yourself, so you better act like a man.
Are all jurors present, sir? Sir. All right. Summon our jurors, please.
Ooh, Lord. Too much going on. Ooh-wee. It's a lot going on, ain't it, y'all? Y'all looking rough, boy. Look like y'all tired, exhausted.
Yes, sir. Ladies and gentlemen, please be seated. All right, Ms. Hilton, you may continue, madam.
Good afternoon. When we left, I believe that I'm showing you what the Martin State Exhibit 373 Yankee. looking at what's in front of you as 373 gatekeep and what's on the screen, does that appear to be the same image that's in front of you?
They look the same.
Okay? And is the image on the screen clearer for you than the image that's in front of you?
No, they look the same.
Okay? If I enlarge it, are you able to tell who's in the picture in 373 gatekeep by enlarging the picture in front of you?
Nope.
No. Now show 344 again.
Which one it is?
Is this 348 Yankee, my apologies. Is that 348 Yankee in front of you?
You already showed me that one.
Okay, and before I think you said it was blurry as well,
No, I answered you.
for this one. I want to admit if I have it, thank you so much for correcting that 348 Yankee. You like to admit 348?
Any objection to the state's 348 Yankee?
She was asking him the same question over and
It's
over.
already been, I thought it was been already.
It could have been.
Oh, yeah, I thought it was been already. 348 Yankee.
Stacy did a 344 Yankee. Were you able to identify who was in 344?
No.
I'm gonna skip a little bit, y'all. We done got. I would not look at Wooded early no more in my life.
It can be described, so I'm objecting to the.
When was 164 admitted, Christine?
That would have been an agent race.
Fine, fantastic. I have Echo 164, Echo Alpha, Echo Bravo, Echo Charlie, Echo Delta, Echo Echo, and Echo Foxtrot. Were admitted.
Yes. And those are all the full records of the
Sure.
section.
Show those to Mr. Steven, please.
The original exhibits.
Yeah, and so that, so satisfied that that's from the original exhibit.
Oh, what are we doing?
It can be described, so I'm objecting to the, going one by one, that's why you have so many. And I'm objecting to foundation of 164EL, because the gentleman testifying said, I believe, I don't recognize her or something like that.
Yes,
Evidence has been admitted, so
but it's still subject to an objection.
the objection is relevant objection, but we could publish, I really could publish this as a show frame and ask who's in the picture.
But if he doesn't recognize it, it's still
So you
subject.
just say you're gonna recognize that person, but it's still an evidence that's published, it's relevant. So the only
Well,
objection
here's,
is relevant. Because it's admitted that.
y'all come on up.
So she just talking over you, Judge. They need to start disrespecting you. That's what I don't like. She stood right there and just talked over you.
And then lastly, Mr. Copeland, looking at the computer screen, do you see the same picture that's in front of you, 164 Echo Gulf?
Yeah, I see it.
Okay. Yep. enlarging the picture before you say that this is blurry too.
Yeah, that's blurry too.
So I'm saying that you cannot see who is in once people echo.
I cannot see who in it on the computer.
Alright, now I'm gonna start publishing pictures. I'm gonna first publish what's already been admitted as 56 felonies.
I don't know why okay, law and crime. If you're looking at this video, what happened to the mic?
Looking at 56 felonies, who's that?
Me and Young Thug.
And I wanna scroll in. Do you see where it says taken?
I'm not good at reading.
Okay, you see the second line on,
2014. That's what he said. That's what Lil Woody said.
what's on the picture? You see where it says taken right here?
This line right here,
Yeah, going over,
right here.
yep. And going this way, do you see a year? You see a 2000 number?
2014.
Yep, right there, what's that?
2014.
So that's 2014?
Oh, okay, my bad. 2014.
All right. Now I want to go down to the bottom with the text. All the way to the bottom.
This one right here.
Can't see it.
Oh, yeah, I'm sorry.
Can you see where- Can you move it up on that screen?
Well, y'all, this part right here of the trial, Lil Woody is describing Young Thug. This
Not that I
Woody.
know of.
And it seems like she want him to describe somebody else.
Now, this part with the zoom, like you've been doing on that screen.
Yeah, but they doing it on his own.
2015. I believe he been crazy all his life. He been a knucklehead all his life.
What's the date on,
Woody,
say, take a line and we talk about it.
about that action.
2015.
Did you see a 1 and a 1 next to it?
Yeah.
With the January 1st, 2015?
Alright.
Taken in and around the same time. This is my first one.
When I took all these pictures, around the same time,
Around the same year, 2014,
Yeah.
2015.
they should have them.
Okay. So we're saying that these are taken around 2014 and 2015. Is that what you're saying?
I'm not being specific when they was taken. I know these pictures right here, the one that I do recall, was taken around the same time.